Hey everybody, we're live. I'm going to get my stuff all set up here and then set up what is going to be beginning in 5 minutes, if they are timely. They're over at the Supreme Court in Oklahoma. So I'm going to pull up my page here. Very good. And I got my volume down, so that's not going to annoy me. I'm sorry to people who watched my segment yesterday and the audio wasn't loud enough. You had to turn it all the way up. So I should have the audio loud enough now for you to hear just fine. Oh, heck, there's already 5 people with me. Hey, guys, go ahead and sign in. And, oh, hey, John, how you doing, man? I haven't seen you lately. You been okay? Thanks for the heads up on the audio yesterday, by the way. I'd chomp my ice, but hopefully I won't do that during the whole thing today. Oh, all right. I was going to call up the Facebook live stream right here. Anyone else who's joining me, just go ahead and sign on. I think I see that there's 9 now. I need that screen to be closer or bigger or something. Oh, wait, can I just... I don't know if you're going to be hearing that. I've got people who are on site going to be texting me. Oh, yeah, that makes it bigger. Oh, hey, Ed, how you doing, man? Well, John, there's worse things than being busy, isn't there? So I'm happy for you. I've missed seeing your consistent posting on my content, though. All right, let me see if I can't. So, all right, if you're with us right now, if you haven't seen yesterday's segment, First Church Oklahoma City, Church of the Servant, also in Oklahoma City, are 2 big facilities that are largely taken care of by conservative or just unhappy with the annual conference leadership. Church of the Servant has been... they got a lot of pressure and intervention from conference leadership last year when they took their vote, just barely missed their disaffiliation vote. We're told they could have another vote. The conference backed off of that promise. They've been, they filed suit in essentially getting the courts to compel the annual conference to follow paragraph 2553. First Church filed against the conference because the conference designed a process for them to go through paragraph 2553 differently from everybody else, and then they neglected to see the process through, essentially. So both churches have filed against the conference to let them go through the disaffiliation process in earnest. The conference up until now has argued we don't have to do anything we don't want to do. And courts, you can't make us do anything we don't want to do. So this is a First Amendment. They're trying to make it, the conference is trying to make it a First Amendment issue. And then the representatives of the churches are trying to make it a neutral principles thing. Oh, okay. We're going live. I'll hopefully add good commentary along the way.
United States of America, state of Oklahoma.
9 Supreme Court justices, 2 of them...
Good morning. Please be seated.
Canceled themselves out of this. That's not the right word. One of them had been tied to a United Methodist Church before that disaffiliated, so that's information from a person this morning.
The Supreme Court of the state of Oklahoma is now in session. We have 2 matters before us this morning. We have the Oklahoma Annual Conference of the United Methodist Church et al.
Oh, I need to switch the camera angle, don't I? You want to be able to see this.
United Methodist Church of Oklahoma City. That's case number 121.
There we go. Everybody confirmed that it looks and sounds okay.
The same petitioner versus Judge Timmons and the United Methodist Church of the Servant. That would be case number 121538. I am Chief Justice John Kane, and we have a couple of special justices in this matter, so I'm going to go ahead and introduce the bench.
Oh, thanks, Ed. It's called recusing. Hey, CRM Ranger from Georgia.
Of Tishomingo. To my left, your right, is our Senior Justice.
Thank you, Harrison. 12-281. I'm glad it looks and sounds good. This is a good sign.
To my right is Justice James Winchester from Chickasha. To my left is Justice Douglas Combs from Shawnee. To my right is Justice Richard Darby from Duke. To my left is Justice Dana Keene from Tulsa. To my right is Special Justice Scott Rowland, who is the presiding judge of the Oklahoma Court of Criminal Appeals. And to my left is Judge Barbara Swinton, who is a judge on the Oklahoma Court of Civil Appeals. So with those introductions of the court, I'm going to ask Mr. Plord and Ms. Plaxico to introduce
Now,
the
the
folks at
blurring,
council table. So
I'm
I'll
seeing it
start,
on my
with
end
the
as well. I
petitioner,
think it's
Counsel
just
Ross
their
A.
upload
Plord.
speed. So it's clear, it's getting clear every now and again for me, but this seems to be as good as it's going to get. Oh, that's the Bishop Jimmy Nunn at the bottom left there. Yeah, there's Bishop Nunn.
Thank you, sir. And for the real parties in interest.
Good morning, Chief. I'm Cheryl Plaxico. This is my teammate here, Nicholas and Ashley.
Come on, cameraman, show us.
Representative of the First Church is Arden Patton, and for Church of Servant, we have Monica Whitlock.
Thank you very much. All right, I'm going to review the procedure that we intend to follow this morning briefly. The two cases have the same counsel and the same petitioner, and we're going to consolidate the argument of both cases. And the petitioner has requested and will receive 25 minutes of opening argument, after which time the court may have questions. The real parties in interest will have 30 minutes in which to respond, and the petitioner has requested and has been granted leave to have a 5-minute rebuttal, so that each side will have 30 minutes of argument. Do counsel have any procedural questions prior to commencement of the argument?
Are they just going to talk straight for 30
Excellent.
minutes?
Okay. Well, I'm going to go ahead then and invite the petitioner to proceed forward. And is the clerk going to be our timekeeper?
So that's the counsel
Thank you. Okay, I
for the
appreciate
annual conference right there. So
Thank you, sir. You may proceed.
Thank you very much, Your Honor. At issue in these cases is whether the district court had the power to preside over and order relief involving only the ecclesiastical law of the United Methodist Church, the Book of Discipline, and 2553, which was enacted in 2019 as part of the discipline.
So yeah, he's saying they don't have a right.
And
to-
those,
the courts have no right to get
related
involved here.
To the dissolution of the bonds of membership in the United Methodist Church. We believe that issue is an issue of subject matter jurisdiction. But whether the issue is treated as subject matter jurisdiction or as an affirmative defense, we submit that the district court did not have the power to intervene in those disputes or to grant the relief that was sought and granted.
Let me interrupt you for just a brief moment, Counselor. Can you tap that mic? I just want to be very sure it's live. Okay, just want to
I'm
be
not
sure.
doing a good job of projecting.
Thank you for your help.
Of course, the court will control the agenda today, and I respect that.
He's a nervous
Let me
fellow.
give you a sense of what it is that I hope to cover for my part of it. This is not a property dispute. There are no property rights involved. The Book of Discipline is not a contract. It doesn't create property rights in and of itself.
So they're going to argue
And the
against this
long
very
history
strongly.
of the decisions of the United States Supreme Court relating to these kinds of issues indicate that the issue is one of subject matter jurisdiction. I don't think that the Hosanna-Tabor case changed that, except for that special circumstance that they addressed.
That's not
And the
something
long
that we've
history of this
discussed
court.
up till now, but that would be some important
replete with this
jurisprudence.
court treating the issue as subject matter jurisdiction. And I don't believe Hosanna-Tabor or Doe changed that except for the circumstances that were involved in those cases. Let me turn to
Thanks, Harrison.
to the property rights, and it's never been. I've heard the real party and interests.
Yeah, the Book of Discipline is clearly
arguments on this
a
few times
contract,
now, and
but
it's never been clear
they're
to me exactly what it is.
it's
is
in a
that they're
section
alleging
here
as property rights.
that deals
it's
with
certainly
property.
not the real property of the church. 2501 of the Book of Discipline, paragraph 2501, makes it clear that the property of these churches is held in trust to the United Methodist Church. And 2501 contains some pretty significant language, I think.
It's a packed house
It
there
says,
this morning.
"This trust requirement is an essential element of the historic polity of the United Methodist Church or its predecessor denominations or communions, and has been a part of the discipline since 1797. It reflects the connectional structure of the church by ensuring that the property will be used solely for purposes consonant with the mission of the entire denomination as set forth in the discipline. The trust requirement is thus a fundamental expression of United Methodism, whereby local churches and other agencies and institutions within the denomination are both held accountable to and benefit from the connection with the entire
Yeah, John, your wife
worldwide
Lisa is
church."
on the second
I don't
row,
think
she
there can
said.
be any dispute about the current ownership of these real properties and the physical, tangible property. To the extent that the contention is that paragraph 2553 of the discipline created some sort of a property right, some sort of intangible right, I don't believe that's the case either.
He's going to have
It
to
doesn't
contend.
create a right at all.
No, the words
The
limited
language
right are
of-
in
of
2553.
2553 talks about a limited right
Yes.
to disaffiliate.
Yes.
But 2550, let me back up just a little bit. Within the United Methodist Church, the highest judicial authority is the Judicial Council. And the constitutionality under the United Methodist Constitution was taken up to the Judicial Council. And in decision number 1379, the Judicial Council said, you know, this is unconstitutional, except for the fact that you have to read 2553 in connection with the other provisions of the Book of Discipline, and another provision of the Book of Discipline, 2529.1b3, says that the annual conference, each annual conference, is the sole arbiter of when a church can leave the United Methodist Church. And so it's discretionary with them. The General Conference can't, according to that decision, 1379, can't require the annual conference to approve disaffiliation. And so when I say it's not a right at all, that's what I'm referring to, is that it doesn't create a right, it creates a path to get to the annual conference to seek approval of disaffiliation. But at the end of the day, it's up to the annual conference. Second, it creates a process for disaffiliation. 2553 creates a process. It doesn't create a right. Membership isn't a
It says
property
limited right, but it doesn't create a right.
This
Okay.
court in Fowler versus
It doesn't
Bailey
mean what it says.
in 1992 said that church membership by itself is not a civil or property right subject to civil judicial regulation. And if membership isn't a right, a process to dissolve membership, which is what this is, doesn't create a property right either. And this is not a property dispute.
I'll say it again. Maybe it'll make it true this time.
These cases involve an effort by two churches to enforce their interpretation of the Book of Discipline.
Or any sane person's interpretation, maybe?
The issue heard by the district court was a vote
Yeah,
on
Reuben Sam Powers, I
disaffiliation.
think, is there.
The district court was not asked to determine
Yeah.
ownership of property.
Yeah, he's definitely there.
The petition doesn't allege a violation of any property rights. There's no discussion in the order in either case. I'm sorry. There wasn't an order entered yet in the Church of the Servant case, but in the first church case, and in the oral announcement of the ruling by the district court, there wasn't any discussion of Oklahoma property law. And in fact, the order that was entered in the first church case began with the following statement: "The matter before this court deals with the enforcement of the Book of Discipline of the United Methodist Church." This was not a property dispute. It would become a property dispute if there was a disaffiliation and either church claimed title to the property. Then it would become a property dispute.
That's like saying
but
a fetus is not a human because it hasn't been born yet. It's in its very nature, it has huge property implications.
That's been a characterization throughout these cases that the discipline is a contract. It wasn't negotiated between either of these churches and the United Methodist Church. The discipline is enacted by the highest legislative body in the United Methodist Church, the General Conference, and it's amended every 4 years, I believe, to some extent. And it applies whether or not an individual church has signed on to that, or an individual member of the United Methodist Church has signed on to it. When you become a member, you essentially agree that you're going to follow and comply with the Book of Discipline as enacted from time to time by the General Conference.
You signed on for this, so you have to agree to any unfair new legislation or however they choose to enforce it.
I think there's a tendency to think of ecclesiastical law as something much more limited, but I've got to confess my Black's Law Dictionary is still from 1979, but I don't think it's changed any, and it says that ecclesiastical law is law applying mainly to the affairs and the doctrine, discipline, and worship of the established church. It's much broader than simply what the church believes or the sacramental practices of the church. We believe ecclesiastical law is for the church to construe and apply, as opposed to the courts. The basis for that starts with the antecedents in the United States Supreme Court to Hosanna-Tabor. And that goes back to 1871 in the Watson versus Jones case, where the court said civil courts exercise no jurisdiction over matters of church discipline, ecclesiastical government, or the conformity of the members of the church to the standard.
This is what I think is going to be key. He's arguing that ecclesiastical abstention doctrine, where the government cannot get involved, that is constituted by anything that a church writes. So it's not just doctrinal stuff. It's anything that they put in writing that is constitutive here. So he's acknowledging this isn't doctrinal, even so it is still ecclesiastical.
Morals required of them. Jump forward to 80 years and to the Kedroff versus St. Nicholas Cathedral case.
So he's going through jurisprudence now in America.
Where the court said the First Amendment guarantees the rights of churches to decide for themselves, free from state interference, matters of church government, as well as those of faith and doctrine. And then in 1976, the Serbian Eastern Orthodox case, where the court said that the Illinois Supreme Court, in interpreting internal church law, had unconstitutionally undertaken the resolution of quintessentially religious controversies whose resolution the First Amendment commits exclusively to the highest ecclesiastical tribunals of this hierarchical church. And then Jones versus Wolf. In that case, a majority of the members of the local church had voted to leave the Presbyterian denomination, and the dispute was between the denomination and the local church majority over ownership of the property. There was no trust clause in the deed.
I wish I was more familiar with this stuff so I could add helpful commentary. I don't know if his rendering of this stuff is
didn't adopt a trust clause
true or not. I'm sure it's mostly true.
In the Book of Discipline as well. The Supreme Court in Jones versus Wolf approved the use of neutral principles of Georgia property law to resolve the ownership dispute. But it's interesting to see what they remanded it for. They remanded it for a determination regarding whether the local church was properly represented by the majority who voted to leave the denomination or the minority who stayed. And they talked about it would be appropriate for a court to base that determination on the majority in most cases. But where the property is held in trust, it may not be appropriate. And they said that
May not or is not?
Georgia law indicated the possibility that Georgia law itself required that property held by a local denomination in a hierarchical church
Which the United
is held in
Methodist Church
trust
is.
for the hierarchical church. And they indicated if that's the case, then you need to look to, I believe it's the Book of Order in the Presbyterian Church, to determine who the true congregation is. And they said that such a determination, however, would appear to require a civil court to pass on questions of religious doctrine and to usurp the function of the commission appointed by the presbytery, which already has determined that petitioners, the minority, represent the true congregation of the Vineville Church. So while Jones versus Wolf may have allowed the court to employ neutral principles of state law to resolve property disputes between already separated factions of a church, it didn't authorize the courts to usurp the function of the church in resolving intra-church disputes over laws and regulations of the churches. And it certainly didn't sanction court participation in the separation process itself.
Yeah, Eileen,
The
I'm
decisions of
told
this
by
court
someone
are
in the courtroom there
consistent, I
that
believe,
the
as
sound
well.
system is not doing well with his
In
voice.
Block versus,
They're pessimistic that the
excuse me,
older
First,
justices are going to be
English
able to track with
Lutheran
him.
Church versus Block, this court said, civil courts will not review acts of religious organizations relating solely to internal ecclesiastical affairs for the sole purpose of ascertaining whether they are in accord with the policy, discipline, or usages of the organization. Gwynn had similar language. The class, in that case, Justice Apollo said the class of religious dispute, which the court has traditionally held to be outside the purview of civil judicature, involves arguments among members over interpretation of church doctrine or over actions taken pursuant to allegedly incorrect construction of church rules. And then Fowler versus Bailey, the court said, we are strongly committed to the correctness of the decisions holding that church membership is within the ambit of ecclesiastical jurisdiction and outside that of civil courts. So the question is, did Hosanna-Tabor change that?
Has he been
Did
talking Hosanna-Tabor this whole time?
Take
No.
all of those decisions?
No. He was going,
Throw them out
okay.
and say, from now on, this isn't jurisdiction. This is an issue of whether it's an affirmative defense. And we believe that's not the case. That was an ADA cause of action. It didn't arise from an alleged breach of a church-created benefit or process, as in this case. The defense was that the church didn't have to comply with the ADA because of the ministerial exception. The Supreme Court said that the teacher in that case, who was a teacher for the church school,
Yeah, Reuben, I think that's a good word.
was a minister, and therefore the ministerial exception applied. And then, of course, there's that footnote 4 that says we conclude that the exception operates as an affirmative defense to an otherwise cognizable claim, not as a jurisdictional bar. First of all, here the claims are created or based on church-created procedures that allegedly creates a right. It governs the process of disaffiliation, and their claims all seek enforcement of or are based on that process. The claims wouldn't exist but for that process. In the Hosanna-Tabor case, Justice Roberts discussed at length and quoted from Watson versus Jones, Kedroff, Serbian Eastern Orthodox Church. Those are all subject matter jurisdiction cases. He didn't say, we're departing from that, we're going a different route. He
I'm
quoted
not sure
them
you
with
have
favor,
to.
or
Oh, he
cited
quoted
them
him with
favor.
favor. Okay.
He didn't overturn those decisions. And in fact, in discussing the Serbian Eastern Orthodox case, Justice Roberts in Hosanna-Tabor said, we thus held that by inquiring into whether the church had followed its own procedures, the state Supreme Court had unconstitutionally undertaken the resolution of quintessentially religious controversies whose resolution the First Amendment commits exclusively to the highest ecclesiastical tribunals of the church. So Hosanna-Tabor didn't depart from the subject matter jurisdiction basis.
Subject matter jurisdiction basis.
Doe's ruling obviously is based on Hosanna-Tabor.
I think he's making the case that
Hosanna-Tabor didn't overrule
ecclesiastical bodies can do whatever they want.
Of the United States law regarding subject matter jurisdiction.
Obviously.
The issue remains
that it's not at all pertinent whether or not they're observing their own rules.
Hosanna-Tabor and Doe, or is this case more like Watson versus Jones, Kedroff, Serbian Eastern, all of which held that the First Amendment precluded the exercise of subject matter jurisdiction over internal church disputes. And we submit it's more like the latter. The linchpin of Hosanna-Tabor is whether the teacher was a minister. That was a fact issue that had to be addressed before the ministerial exception applied, and it's logical to treat it as an affirmative defense. The linchpin of Doe is membership. There was an issue as to whether Doe was a member, whether Doe had agreed to be bound by the rules of the church. Justice Watt said ecclesiastical protection for a church arises solely from membership and the consent of the person to be governed by the church. Under Gwynn, a church has no defense of ecclesiastical jurisdiction for a claim brought by a non-member like Doe. So where the resolution of the issues turns on a fact question of membership, of the status of a minister, it's much more reasonably or readily characterized as an affirmative defense. Here, membership is not an issue. It's a dispute between members. There's no issue about that. It involves
when he says member, I think he's talking about local churches, not individual church members.
In that sense, it's similar to the church split in Watson versus Jones, where the court
John, I'm pretty sure that they knew jurisprudence was going to be a big part of today.
In which
yeah, I'd be very surprised if they weren't prepared to answer these.
As to whether that non-member had consented to the alleged practice of the church of publicizing baptisms.
Hey, good.
There's a
Thanks,
couple
buddy.
of other critical considerations regarding whether to treat this as an affirmative defense or subject matter jurisdiction. And I think the primary one is that an affirmative defense is subject to waiver. It can be waived by not asserting it. It can be waived by a default judgment being entered. And if that happens, and it eventually will happen if it's an affirmative defense, you know, you've got the court entering an order that could be related to the manner of serving communion, the ordination of clergy, the marriage rights, directing the church how to run the church. If it's an affirmative defense and it can be waived, then those are all possibilities. And I don't think society really wants that, to allow that level of court intervention in the operation of the church.
So he's making an argument similar to what I've said, which is if this gets set as a precedent, there's going to be a lot more intervention in churches.
In a religious dispute,
that would not be good.
I believe it's something that needs to be resolved at the very early stages of a lawsuit before subjecting the church to protracted and costly litigation.
Yeah, it would be nice if they had taken care of this before it escalated. Yes, I agree.
Not just the expense, but the intrusion, and even a minor intrusion, the Supreme Court has held is unpalatable. It's not permitted under the First Amendment. This court's decision in Gwynn referred to the class of religious disputes which the court has traditionally held to be outside the purview of civil judicature, involving arguments among members over the interpretation of church doctrine or over actions taken pursuant to allegedly incorrect construction of court rules.
We've got more than
because
50
these
people on the live
cases
stream
involve
now. If you
a
haven't
dispute
already, go
among
ahead and
members
sign
of the
in. Let me
United
know who
Methodist
you are,
Church
where you're from.
over allegedly incorrect construction of the discipline, it is, in fact, in the words of Justice Apala, outside the purview of civil judicature and should have been dismissed on jurisdictional grounds. The district court certainly lacked the power to grant the relief that she ordered because it fundamentally purports to address an allegedly incorrect construction of church rules. Even if the court had jurisdiction in the First Church case, it abused its discretion, and this is just First Church, but in that case, she certainly abused her discretion.
He's
in
talking
entering
about
the
Judge
injunction order
Timmons
because it
in the
violated
previous
discipline,
case.
the very doctrine that she set out to enforce in so many ways.
Okay, saying that her ruling
We believe
violated the
under-
Book of
under the First
Discipline
Amendment,
on
intra-church
which
disputes
behalf
such
she
as
was
this are supposed to
intervening.
be resolved within the church. There's a process within the United Methodist Church for doing
Hey, Bill.
it.
Hey, John. Hey, Christopher.
It's in some respects where there are complaints about individual ministers or the bishop, there's a process for resolving that.
Yeah, but they don't follow the
bringing in upon
process.
charge.
That's the thing.
Where the issue is, are you complying with the discipline?
Yeah,
There's a process for resolving that.
there is, but it's not followed.
It can go a couple of different ways to get to the Judicial Council, but certainly one way is for the party who believes that the conference isn't following the discipline, or the staff of the conference isn't following the discipline.
Yeah.
You ask for a ruling from the bishop at an annual conference meeting.
Yeah, he's not going to do that.
And if you're not satisfied with the bishop, you can get 1/5 of the members of the annual conference to essentially certify the issue for consideration by the Judicial Council, and they can make a determination as to whether or not it's in fact in compliance with that. These churches had plenty of time to do that. They could have done that. They
No,
didn't.
they did not have plenty of time to do that.
Instead, they resorted to the district court.
Mm-mm.
And the district court's intrusion into
hey,
into
brother.
that process,
Glad
no
you're
matter
with me,
how
Daniel.
slight, diminishes the protection afforded
Oh,
the
and
free
Dan
exercise of
Crabtree,
religion.
good to see you, buddy.
That harm
from Kentucky.
extends far beyond
Welcome.
the present dispute within the United Methodist Church. The district court essentially has let the world know that it's open for business to resolve internal church disputes. If you don't like the process the church has established, the district court will manufacture a preferred process. The dispute today is over membership in the United Methodist Church and how the bonds of that membership may be dissolved. That in and of itself is a pretty fundamental religious issue. But once the courts elect to adjudicate allegedly incorrect construction of church rules, the dispute tomorrow could easily be over church rules relating to communion or ordination or other church practices, and whether or not one agrees with how the United Methodist Church is seeking to deal with human sexuality issues. We believe that's
I think he just
it's
said
simply beyond the bounds
that if the
of
court
the
gets
jurisdiction
involved
of
in
the
how denominations do property,
Thanks, sir.
then there's a slippery
I've got
slope
couple
to
of questions
them
for you.
getting involved in doctrinal stuff
I'm
as
going to
well.
start with something you just
I don't think that argument holds
addressed,
up.
and that is the process of seeking relief before the United Methodist Church Judicial Council. Now, the real parties in interest argue that they have no remedy before that body. Can you address their concern to me at this time?
Well, again, both churches, there was an annual conference meeting in May. The matters that they're complaining about, and it would take me some time to go through each one of the matters, but each one, they could have stood up at the annual conference meeting and said, for instance, hey, we don't believe we should be subjected to
That would have been ruled out of order. It was a special
church
called
liability
conference.
study.
That
We don't
the
believe we should
bishop
be,
would have not
subjected
allowed
to
that.
And they could have asked the bishop to rule.
We were limited to what
as
was on the
whether they
agenda.
had to comply with that.
Hey, Duncan,
And
how
if
you
the
doing, man?
bishop said, yes, you do, and they were dissatisfied with that, they could have, again, asked the members of United Methodist Annual Conference meeting. There was about 500 at that time. To allow them to pursue that before the Judicial Council. And you know, at that meeting, there were 55 churches that were disaffiliating who had representatives at that meeting. There's a decent chance they would have gotten 100 members to
Yes,
to
we would
vote
have
to allow
happily
that to be
gotten
pursued
on board with them.
before the Judicial Council. And
They
didn't
were
do
not
it.
clear as a
Same
church
with,
as to what was
with
going on
Church of
right
the Servant,
then.
Church of the Servant.
We,
You know, the
the bishop would
provision,
not have allowed it to go
establishing
forward.
you have to wait 1 year after your vote has failed in order to seek a revote.
That's not in paragraph
They could
2553.
have presented that at the annual conference meeting, got a ruling from Bishop Nunn, and then pursued an appeal of that to the Judicial Council. There are internal processes, and to the extent that they're saying, well, you know, these individuals have you know, manipulated the system or whatever, they have a right to bring charges against those individuals. And
Yeah,
and
Duncan, that fraud
the
word's
process
pretty
is
important,
very
isn't it?
detailed. It's contained starting at paragraph 2701, I believe, of the discipline. And I'm not going to try to recite it, and you wouldn't want me doing it. But it's very detailed. It provides for fact-finding commissions and bodies to review it and determine whether, in fact, there has been a violation or infringement of an individual upon the rights or privileges granted by the Book of Discipline.
All right, thank you. Also, the real parties in interest are suggesting or have suggested that your legal argument is ignoring the effect of Jones versus Wolf, the 1979 U.S. Supreme Court case that sets forth the neutral principles doctrine. Do you think that abrogated the church autonomy doctrine?
No, it established the right to rely on neutral principles in the context of a property dispute. It didn't say, well, you know, to the extent that for instance, that you can treat the Book of Discipline as a contract and interpret it according to contract principles, neutral principles.
Yeah,
of
neutral
contract
principles,
law,
yeah.
that's okay.
Yes.
I mean, you could take any religious doctrine and say, well, that's a contract, or you know,
He's doing the slippery
some
slope
other,
thing again.
kind of instrument, and therefore we're entitled to interpret that according to the laws of the state of Oklahoma, as opposed to the you know, the internal laws of the church.
I don't think he's answering the question.
There's no end to that, and it completely
Yeah, he's saying slippery slope.
destroys the First Amendment.
So
All
the
right, thank you.
justice
That's
asked,
all the questions I have. Vice Chief, do you have any questions? And Justice Cogger?
No questions.
And
they should ask more questions. He's making up stuff on the fly. He's not saying
Justice
anything.
Winchester? Justice Combs?
Well, I do.
Good.
This court most recently has spoken to the church autonomy doctrine in Doe. You've talked about it a little bit today. Would you distinguish Doe, or would you overrule Doe insofar as subject matter jurisdiction versus affirmative defense?
Well, you know, the church autonomy doctrine is different from the ministerial exception. I think that this court felt it was bound by Hosanna-Tabor to treat the church autonomy doctrine as the equivalent of the ministerial exception, and I think if I had my druthers, I'd overrule it, but I don't get a say in that. But we certainly distinguish it, because again, the linchpin of Doe is membership, and there's no question about members in this case.
Hey, Earl, glad to have you with us.
The churches, when they became United Methodist churches, agreed to be bound by the Book of Discipline, and unlike in Doe, where Doe never became a member, didn't agree to, you know, the practice that the Presbyterian Church in that case said was their practice, He didn't agree to that, and so there's no basis.
It's just a reprehensible position to be in if you're going, hey, they signed up for the covenant community.
The fact question is,
We can
Doe,
invent whatever we
and
want
subject
and
matter
entrap and
jurisdiction
bully
issue
people.
Here.
I believe so, yes.
All right, thank you. That's all, Chief.
Whether or not he's even
Thank you,
right,
Justice
it's
Darby.
just morally reprehensible.
Justice Keene.
I just want to follow up on what Justice Combs just asked you. With Doe, either way, would you agree with me that the majority in Doe really, to put it bluntly, didn't
Sorry,
have any
Paul, I can
reason
turn up
to
the
be
volume,
going
but then
into
there
all
would
of
be a
this
lot more
this doctrine,
noise. It
church
wouldn't be good.
autonomy, ministerial exception, either way, because he wasn't a member of the church. But for some reason, they took Tabor and kind
I'll
of
do it,
mixed
but
it
I'll turn
together
it
with the
back down
church
if it's
autonomy
bad.
doctrine. Would you say that Doe now stands for the fact that the ministerial exception is the church autonomy doctrine and therefore affirmative defense? That's what I think you told Justice Combs. You would overrule it.
Yeah.
Okay, so
Yeah,
if you're
I
going to
think there's
overrule
a-
it, but if you're going to overrule it, then what you're saying is that the church autonomy doctrine is a separate, distinct thing.
It is.
Okay, and that would be the first thing to resolve, because if the law in Oklahoma now is there is no church autonomy doctrine and it's an affirmative defense, that's a different argument for you, correct?
Yes.
Okay, so if we resolve it that the church autonomy doctrine is separate from the ministerial exception, that they're two things but they're separate, then you would resolve the fact that our next step would be, if it's church autonomy doctrine, is this really ecclesiastical matters or is it neutral principle?
Yeah, there you go.
That's our next step.
Yeah,
in our
that's it.
analysis. Would you agree?
Right.
Okay. Is there anything that happened at the trial level that you can point to that their argument is, I think, that the trial judge looked at the end result, which is, you say it's not a property dispute, but in the result, they're saying that the United Methodist Church is stealing the property by setting rules that they're not setting for anyone else, maybe in both cases.
Yeah, Ruben, the problem was they changed the rules after
If
these
that's true,
churches
if there is a
joined.
mixture or they're intertwined.
And then they provided a release valve that they're not
the
allowing to be
ecclesiastical
utilized fairly.
questions and the property questions.
That's the only reason this has
What do you
happened.
think should be the result under a church autonomy doctrine?
Well, again, if it's a matter of determining who owns the, and understand, I'm sorry, I shouldn't use that word. The
Such
point
a
I tried to
nervous,
make
weird guy.
is that where you have a property dispute, where you have a dispute as to the ownership of real property, the church doesn't have any power to bind anybody with that. I mean, the church can't take a disaffiliated or separated faction and say, you don't own that. They can't resolve that issue. That has to be resolved by the court. And as we brought up in the prior argument, I mean, if Church of the Servant or First Church just said, we're no longer Methodist, we're no longer United Methodist, and conference, you're out, we're locking our doors to you, then we're going to be filing suit to enforce the conference's interest, the United Methodist Church's interest in that property. That's a different issue from what's going on here. What's going on here isn't a determination of property, it's a determination of membership. And if Church of the Servant, if First Church
He's saying it is not neutral
successfully goes
principles.
through the disaffiliation process and completes all the requirements under 2553 in the Book of Discipline as to disaffiliating, then they're going to get a deed from us, disclaiming our interest in that property.
So what I hear you saying, at least what I think I'm hearing you saying, so I think I'm clear, is that if there's anything intertwined in the argument, that the church autonomy doctrine should prevail, and and therefore then the court should stay out of it.
That better said than I said.
Okay, no, okay, I just want to make sure I understood where you were. All right, thank you, Chief. I have no further questions.
All right.
Oh, yeah, Ruben. Okay, I understand now.
That may be impossible for
Yeah, that
them
was a
to
helpful
meet.
clarification. Thank you.
Well, Judge Timmons, Judge Timmons wasn't terribly respectful of those time limits.
Judge Timmons and he did not get along.
The provision expires December 31 of this year.
So it's virtually impossible for them to get title to the property.
Yep. Yes.
Again, not if Judge Timmons exercises the level of control that she exercised.
But you don't believe she should do that?
I don't believe she should do that. That's why
Thank
we're
you.
here, Justice.
That was a helpful clarification as well.
Is that it?
Yes, Chief.
Okay, thank you. All right, Special
Got him.
Justice Rowland.
Wave, thank you.
Just a random kid walking through.
No question.
You wait? Okay, Special Justice Swinton.
Yes. Can you tell me, I noticed that you didn't mention anything about the Geldner versus Loomis test that does allow us some leeway to consider property issues.
All right, considering
without
other
violating
jurisprudence
the
that he
autonomy
did not reference
doctrine. Can you
conveniently.
tell me how you could see that we could do that, given the facts that we have here?
Well, the Gelder case involved, again, a dispute between factions over control of real property. The relief sought in that case was injunctive relief with respect to control of real property. And in Gelder involved the Lutheran Church. The Lutheran Church is a congregational church.
Oh,
The
not
United Methodist Church is a
hierarchical.
hierarchical church. The difference is, with a hierarchical church, you have this structure, the bishop, the annual conference, the general conference, and the judicial council to resolve that within the church. Congregational church, like the Lutheran Church in Gelder, each church is a separate autonomous unit. There is no means of resolving a dispute.
I'm not sure that's
as
true.
to control of
Well, there are
a,
lots of different Lutheran
of a-
denominations. I'm not
those
familiar with
autonomous churches.
which one he's talking
within
about.
the church structure itself. But in Gelder, the court had to determine who controls this real property. And again, real property is not something that the church can affect titles to. They can't say, okay, this faction is the owner, therefore, this faction can sell it to so-and-so or mortgage it or whatever, and expect that to have any effect.
If you don't know what he's talking
and
about
so
here, I did
the
an
court in
interview
Gelder
with a
really
lawyer
had
named
to
Lloyd
determine,
Lunsford who explained
and look
this
at
area
kind
of
the
law.
the internal structure of the church in order to determine control. That's not our case here. We're a hierarchical church. There's a means of resolving that issue. If it comes up, it hasn't yet. There's no issue as to who controls real property.
If he was right, there would be they would just leave.
All right, thank you, sir. We appreciate that. And I'd like to hear from the real parties in interest now, please.
All right, we're going to hear from the two churches that have filed suit against the conference. That is not Kara Nicholas, I don't think. There are two lawyers representing them. I forget this one's name. Kara serves on the TLC for the Global Methodist Church, and she's a friend of mine. She does a fantastic job up there. I don't know why she's not presenting.
You may
I would
proceed.
have her present if
Thank you, Your Honor.
if I were king of the world.
May it please the court, good morning. It is a great honor to appear before you this morning, and it's also a great honor to be representing these wonderful congregants of First Church and Church of Servant. Our United States Constitution and the importance of religious freedom to our nation. Religious freedom is the bedrock upon which our Constitution was formed. You are absolutely assured that we are not before you today to in any way erode
Yeah,
that
Ruben, I don't
bedrock
think they're going to
nor
have
touch
anyone
it.
testify today. I think
The fact of the
only
matter
legal
is
counsel
that
is
the
going to be able to
petitioners
represent what's
have
going
a
on.
very high burden in this case, and a burden we submit they can't
Or I
meet.
guess a Supreme Court justice could call
In
on
order
somebody to
prevail
answer
on their
directly,
claims
but I
that
doubt they
Church
will.
of the Servant and First Church are barred from seeking the requested relief from the civil court, that relief being implementation of 2553, which results in release of their property to them. The petitioners must show that the claims are strictly and purely ecclesiastical in character. We submit that can't be done. The showing is impossible because the doctrinal or ecclesiastical disputes that the petitioners attempt to conjure and the resulting parade of horribles that they speak of just simply do not exist. There is no religious controversy, thus no implication or impingement on the First Amendment, at least as to petitioners. Why this is not a religious or doctrinal controversy? The reason is because in 2019, the General Conference, that's the General Conference of the United Methodist Church, the highest decision-making authority of the United Methodist Church, recognized the schisms and the dysfunctions that occurred in other denominations due to the issue of human sexuality. And they decided that, in their own words, they wanted to provide a gracious and non-confrontational right, and I emphasize right, to local churches to disaffiliate, but not just disaffiliate and take their property with them. As Petitioners' Counsel has admitted in most every proceeding that we've had in these two cases, the result of 2553 is the conveyance of property to local churches free of any trust provision. Paragraph 2553 specifically states, and I quote, "A disaffiliating local church shall have the right to retain its real and personal, tangible and intangible property." This case is about property, and the petitioners...
Yeah, she's focusing on the rights language.
Speak on behalf of the UMC. That's an important point that I'll talk about in a minute, and who have testified of their great disdain for 2553, have attempted to strip the rights of these two congregations to their valuable
In the previous
properties.
hearing over Church of the Servant,
87
Sam
Oklahoma
Powers
churches
publicly said
have
how much he hates
successfully
paragraph
been
2553, so
allowed
that's
to
what she was
exercise
alluding
their
to.
rights under 2553, disaffiliate from the UMC, and take all of their property with them. There are 40 to 50 additional churches waiting in the wings to do the same thing in about a week. Yet, here we stand, First Church and the Church of Servant congregations. They're the only two local churches in
Yeah,
Oklahoma
Eileen,
that
somebody
have
in the
been
courtroom said
barred
she's much easier to
from
hear than the previous guy.
exercising those rights, barred by the petitioners. We submit that it is no coincidence that these two churches have extremely valuable properties in Oklahoma City that the petitioners covet. The role of the
Oh yeah,
General
Ruben, all
Conference-
this
whoops, in
hinges on
contrast
paragraph
to the
2553 in the Book of
It's
Discipline.
important
Very
and
clear
really
language.
relevant, I believe, to delineate the parties in this case. The General Conference, who I referred to, the one that implemented 2553, is the highest decision-making body of the UMC. The General Conference is made up of clergy and lay delegates worldwide. It is the only body of the UMC that can make decisions for the UMC. Despite their attempted portrayals, the petitioners are not the UMC. This is not a case between First Church and the UMC, and it's not a case between Church of Servant and the UMC.
Oh, that's a good point to
Instead,
make.
this is a case between two factions within the UMC.
Okay.
Both are bound, notwithstanding what petitioners try to argue, both are bound by the discipline of the UMC. Yet the petitioners have breached the discipline
Yeah.
and harmed these two congregations greatly. I want to mention that the testimony has been in both cases by both district superintendents that they agree that they are bound by the discipline and that they are obligated to make sure that these congregations receive the rights under the discipline.